The Appellate Division, First Department, is now in session. Welcome and good afternoon. Before we begin with the call of the calendar, as the presiding justice of this panel, I have the pleasure of acknowledging our new colleague, Justice Manuel Jacoba Mendez Oliverio, who is sitting today as an Appellate Division Justice for the first time. Before becoming a judge, Justice Mendez gained formidable experience in the courts, both as a legal aid criminal defense attorney and in private practice, both on his own and in partnership with others. He was then elected to serve on the Civil Court of the City of New York in 2004. By 2011, he was serving as an acting Supreme Court justice. In 2012, the people of the state were smart enough to elect him to this New York State Supreme Court, where he served with distinction. Most recently, he was the coordinating judge of the New York City asbestos litigation. Now, we, the justices here at the Appellate Division, have the privilege of Justice Mendez serving with us, and we look forward to many years of fruitful collaboration with him. Please join me in giving Justice Mendez a welcoming round of applause. Welcome aboard.
Thank you. Thank you. Delighted to be here.
Now to the business at hand, we're going to call the calendar. Beginning with the first case, People v. Sanchez. That's a submit. Port Authority versus White near Coastal. Appellant's attorney, Mr. Crowley.
Yes, Your Honor. For the appellant, Crowley.
You have 8 minutes and 2 minutes for rebuttal.
Thank you.
Mr. Hodgkinson, you present?
Yes,
Okay,
Your Honor.
you have 8 minutes argument.
Yes, Your Honor.
Matter of C. Isaiah, that's a submit. Schwalbe versus Bar Chama. Mr. Saad, are you present?
Yes, I am, Your Honor.
You have 6 minutes for argument, 2 minutes for rebuttal.
Thank you, Your Honor.
Mr. Ravala,
Good afternoon, Your Honor. I am present as well.
you have 6 minutes for argument. People versus Ventimiglia, that's submitted. People versus Gallardo, that's submitted. Minor versus East Harlem Tutorial. Ms. Sonnenborn, you present?
Marcy Sonnenborn for the appellant.
You have 8 minutes and 2 minutes for rebuttal.
Thank you.
Ms. Hutter, you present? Barbara Hutter? All right, we'll call this again at the end of the calendar. Let's see. My understanding was everyone was present. Penthouse Global versus the Executive Club is a submit. People versus Basurto is a submit. Candace W. versus Gary Y. is a submit. Landron versus Wilcor Realty is a submit. NYCTL 1998 versus Reverend is a submit. People versus Perez. Mr. Wiener, are you present?
Yes, Your Honor.
All right, you have 6 minutes and 1 minute for rebuttal.
Thank you.
Ms. O'Shea?
Yes, I'm here, Your Honor.
All right, you have 5 minutes for argument.
Thank you.
People versus Milton Narvaez. Ms. Everett, are you here?
Yes, I am.
All right, you have 10 minutes and 2 minutes for rebuttal.
Thank you.
Mr. Kress?
Yes, good afternoon, Your Honor.
Good afternoon. You have 10 minutes for argument.
Thank you.
People versus Bennett Reeves is a submit. Guido versus Fielden. Mr. Scafidi,
Present, Your Honor. Good afternoon.
good afternoon. You have 6 minutes, 2 minutes for rebuttal.
Thank you.
Mr. Zucker,
Present.
you have 5 minutes for your argument. People versus George Cooper is submit. Philo versus Borges is a submit. People versus Booker Morse is a submit. Drew versus O'Neill. Ms. Gustafson, are you present?
I'm here, Your Honor.
You have 6 minutes and 2 minutes for rebuttal.
Thank you.
Mr. Lakazewski, I'm sorry if I mispronounced that. Are you present?
Yes, Your Honor. Mr. Lukaszewski here for Drew.
Okay, and you have 5 minutes for argument. How do you pronounce your name?
Lukaszewski?
Lukaszewski, okay. And I'm just going to go back to Minor versus East Harlem. For the respondent, Ms. Hutter, are you present?
Yes, Judge, I apologize. Can you hear me? I was
I
having
can hear
problems.
you. I can
Okay.
hear you.
I couldn't
All right, we're
unmute
gonna give
before,
you-
so my apologies.
That's okay. We're going to give you 8 minutes for argument.
Thank you.
Okay. All right, before we begin the actual arguments, I want to remind all counsel to please put your microphones on mute unless you're actually arguing your case. In addition, based on the limitations of our virtual world here, only one person can really speak at a time. So we have to be really mindful of not talking over one another and not interrupting one another so that everybody has an opportunity to be heard. The first case for argument is Port Authority of New York and New Jersey versus White Near Coastal Towing Corp.
For the appellant, Your Honor, Adam Crowley.
All right, Mr. Crowley, you can begin.
Okay, thank you, Your Honor. May it please the court. The main issue raised by the appellant at the trial level in its opposition to the respondent's motion for summary judgment in lieu of complaint and on this appeal is whether the contract entered into between the parties qualifies as an instrument for the payment of money only. The contract imposed obligations on the appellant beyond the simple repayment of a debt. And so we feel that it does not qualify for treatment under CPR 3213. Just by way of background.
Counselor, this is Judge Singh. The Port Authority places emphasis on the case diversified. How would you distinguish diversified, and are the obligations of the defendant with respect to the operation of the vessel, are they similar to what occurred in diversified?
And if I'm not mistaken, Your Honor, the situation in diversified was not brought under CPR 3213. I think that was in the context of a motion for summary judgment, whereby I believe the burden would have been on the appellant to raise, tribal issues of fact. In contrast, here we're dealing with motion under CPR LR 3213, which is distinct from that case, and I believe the burden is on the respondent to prove that there was any default, which would trigger the contract becoming an instrument for the payment of money only. The operation of...
So in this case, Counselor, the issue is the percentage of time the vessel was in a particular place, correct?
That's correct.
Can that be decided on a 3213 application on its face?
I don't believe so, Your Honor.
Why? Because
there's nothing on its face to prove that the vessel was not operated within the area for the allotted period of time. The only thing that the respondent has offered is a bill of sale to an entity which is based out of Michigan. That in and of itself doesn't prove that the vessel was not operated for the allotted period of time. Your Honor, with all due respect, I believe that if we go through discovery, it may turn out that there is a debt owed and that the vessel was not operated in the specified geographic area for the required amount of time, but we just don't know.
Wouldn't your
principal-
client know it as the, at least at the inception of the relationship, the owner of the vessel?
Yes, Your Honor, thank you. The principal of White Near Coastal Towing unfortunately passed away in 2017. How we got involved in this case was the estate came to us to basically handle these state matters, and in the course of that, in 2018, this lawsuit came up. The estate didn't have the documentation necessarily to prove or disprove whether the vessel was operated in the specified geographic area, and that being the case, we opposed the motion on a procedural ground that we would need to contact, at the very least, the transferee of the tugboat in question to determine whether or not the vessel was operated pursuant to the terms of the contract.
It's your position, though, that the bill of sale isn't dispositive of where the tug was operated. Is that correct?
That's correct, Your Honor. That's correct, and the reason being, we just don't know where that entity, although they're based in Michigan, where they actually operated the boat. So that being the case, I'm sorry, go ahead.
No, continue.
No, that being the case, we as I said, we opposed the motion for summary judgment in lieu of complaint on the procedural ground that we needed to go do some discovery and figure out whether an obligation was incurred under the contract. And we just can't tell by the face of the contract itself. And we don't believe that being the case, that this particular contract qualifies for treatment under CBR 3213. The respondent has raised another issue with respect to the transfer of the vessel itself. And the contract does not say that. The respondent's position is that in itself is a breach of the contract, triggering the repayment of money. We disagree. The contract actually says that the contractor, the appellant, was not to assign its interest in the contract. There was no default per se in the appellant transferring its interest in the vessel itself.
So the remedy might not be what they're claiming, which is the payment due under the contract that would inure had you not operated it as per the terms of the contract.
Correct, Your Honor. And that being the case, we feel that the appellant, the respondent just basically used the wrong vehicle to prove their case. If they had brought a plenary action, we might have done discovery and determined whether or not there was an obligation, a monetary obligation incurred by the appellant. But we haven't.
Well, even if you're right, what will happen here is that this should become a plenary action. Isn't that the case?
That's correct, Your Honor. But at this point, we were unable to obtain the information to, as I said, prove or disprove whether there was any default under the contract. And that being the case, we're unable to prove or disprove whether there's any monies owed to the respondent.
Do my colleagues have any further questions? Okay, thank you.
Okay, thank you.
Mr. Hodgkinson?
Thank you, Your Honor. Brian Hodgkinson on behalf of the Port Authority of New York and New Jersey, and may it please the court. I think initially I'd just like to address the appellant's assignment argument. So our position isn't that they improperly assigned the contract and thus they're in breach. So that provision is actually much broader than the appellant is saying. It prohibits any kind of sale of any rights arising under that contract. So
it's your position that under the contract, once they sold the boat, even if it was operated in the geographical area that they were required to, they would still owe the money?
Yes, Your Honor.
And the same money, same amount of damages?
Yes, Your Honor. I'll tell you why. So this was a publicly bid contract. So the entity operating that boat is important. So there are certain ethical obligations that the entity who was awarded the contract signs on to. there are certain indemnification requirements, insurance requirements that are kind of lost for third parties now operating this boat instead of the appellant. And to the main issue here is 3213 is the appropriate procedural vehicle for this. So the slight deviation from the contract is the bill of sale, which I believe presumptively raises the presumption that this boat is no longer operated in the non-attainment area if it's sold to a buyer in Michigan.
But why is that? I don't understand that argument. If in fact it was being operated as per the contractual terms, why would Port Authority be entitled to a windfall in essence?
Yes, Your Honor, because we contracted with Whitenear Coastal Towing, not some other entity. So once Whitenear Coastal sells that boat to somebody else, it's no longer beholden to us. So we don't know what's going on with that boat. We don't know where that boat is.
So let's assume that let's assume for argument's sake, it was being operated in the appropriate area for 80% of the time. You still believe that that Port Authority would be entitled to damages?
Yes, Your Honor, because
it's a different party doing it?
Well, we have no idea who that party is. We have no idea what their background is. We have no idea if they have the requisite insurance. We have no idea if they're actually maintaining the boat.
But to that point, aren't those issues that can be thrashed out in a plenary action where there is discovery and we have a record for you to make that argument?
Well, but we contracted with Whitenear Coastal, not some other company. So Whitenear Coastal signed on to this agreement and agreed to do it. They agreed not to sell the boat. They sell the boat. It's important to us that we know who was actually operating the boat, who we're in contract with, how they're operating the boat, who they're employing to work on the boat. Those are all key issues to the Port Authority under the contract, which are kind of thrown out the window once Whitenear Coastal sells the boat to an anonymous third party.
So let's assume that the new entity was in fact operating the boat precisely under the same terms. You still believe that there's a breach?
There is still a breach, though the damages may be different. But
okay, so then how, based on that concession, how is this a 3213 motion? I mean, how can we make those decisions at this juncture?
Because I think whatever discovery, whatever documents the appellant needs are within its own control. The Port Authority has
But you have to make out a prima facie first, correct? How you made that out in this instance? You rely on diversified, and if I'm not mistaken, diversified is a 3213 motion, correct?
It is, yes.
And in diversified, there was essentially a ministerial act that the party had to do, and it didn't do, and we said that was sufficient for 3213 purposes. How is that analogous to this case?
Because the bill of sale to a buyer, a foreign buyer, I think raises the presumption that the boat is no longer in that area. If the appellant had something in its possession that could show some kind of discovery that it believes would counter that or show that we're wrong or that it is still in the non-attainment area, it would have attached it to its motion, or it would have at least made the allegation, which it does nowhere throughout its papers in the lower court or here, that the boat was still in the non-attainment area.
Well, maybe that's a good document for summary judgment, but why is it a good document for summary judgment in lieu of complaint? That's my first question. My second question is, what do you mean by presumption? Is it a legal presumption? Is it a rebuttable presumption? Is it an irrebuttable presumption? I'm not sure what you mean by that.
Yeah, sure. So I think it would be a rebuttable presumption. So as a matter of practicality, you sell a boat to a foreign buyer. I don't think there's any reason to believe that the buyer is going to continue to operate the boat in an area 500 miles to the east.
So it's not a presumption, it's an assumption. That's what it sounds like.
Well, I think just as a matter of practicality, why would the boat still be in this area? If they had something to kind of prove that the boat was still there, they would have attached it to their papers. So what are we going to discovery for? If, otherwise it's just we're kind of chasing a phantom here. So if they had something, they would have said it. We don't have anything at all. Whatever discovery they need is within their own possession. So it seems like they're just kind of
not. I mean, your adversary raised the fact that he believes he's in the unenviable position of representing an estate. The actual principal of the corporation is no longer available, so they might not have the documents. I don't think that that's implausible. Do you?
No, Your Honor. But in the same sense, they took on these obligations and then breached the contract. So I don't see why we should be stuck with.
I don't know that they took them on. They were foisted on them legally. They're the estate.
I meant the entity itself, Whiteneck Coastal Towing.
Yeah, the entity had the obligation, so we're guided by the contract.
Yes, Your Honor. And I
We have
think
to know whether there was performance or not performance, and if there was no performance, if there was a breach, what was the nature of the breach and what are the damages that flow, right?
yes, Your Honor.
Hmm.
Well, there was clearly a breach when they sold the boat to begin with. Where the boat goes after that, admittedly, we don't know. But again, we didn't contract with some anonymous third party.
Counsel, Counsel, I have a question to ask. So let's look at the sale aspect of it. Your position is, look, they sold the boat. That automatically means that I'm entitled to 3213 because they sold the boat. We entered into agreement with the appellant, not with some other third party that comes ultimately later on and buys the boat, right?
Yes, Your Honor.
Okay. So is there an argument to be made? Because I think the appellant made the argument that, yeah, we sold the boat, but if we're still running the show, it doesn't matter who owns the boat. So why is that not permitted? Because he said, I believe he argued, he made the point saying, we didn't assign the contract. The agreement we have with the Port Authority says we can't assign the contract. We didn't assign the contract. We sold the boat. There is a distinction there. So how's that play out then?
Because I think the lack of any documentation or any kind of affidavits in their response to our motion for summary judgment kind of indicates that they're really not running the show. I think they have no idea where the boat is. And I think that's the core issue here.
Okay. Got it.
Okay. Any further questions for Mr. Hodgkinson? Thank you. Mr. Crowley, you have 2 minutes rebuttal.
Thank you, Your Honor.
So that's the point that I wanted to make, that he made, that, I mean, you would have at least the document showing that you only assign, you didn't assign the contract, right? I mean, that's your point, right? So don't you have any documents to back you up on that?
Unfortunately, we don't, Your Honor.
That's not good.
It was an untimely death of the principal, and his affairs were sort of not in order.
Well, not so much. You don't have to go to the principal. You go to the purchaser.
Right. We didn't have the chance to do that, Your Honor, because of the way this case was brought by a summary judgment in lieu of complaint. We didn't have an opportunity to go to the purchaser. We didn't have an opportunity. Wait a minute.
How many days did you have to respond to the 3213 motion that you say you didn't have an opportunity to go to the purchaser?
It's not that we didn't. I'm sorry, I should rephrase it. It's not that we didn't have an opportunity to go to the purchaser. When they were initially approached by us, they were very evasive. Somehow they think they were going to be caught up in some sort of liability here, and they weren't exactly cooperative, and our time kind of ran out to respond to the motion.
Well, that's not fair to the Port Authority. That's not the Port Authority's problem. That's your problem.
It is, Your Honor.
You know, I mean, at this point, it's like the Port Authority says, "Oh, we cut a deal with the appellant, and now the appellant is no longer there. Why can't that be prima facie that they're not going to be able to follow the contract as is with the 80%? We should get what we should get paid because that's what we got. I mean, they haven't shown anything that, you know, they're not there anymore. Now you're telling me that the purchaser doesn't even want to cooperate with you.
Well, if we were in discovery, in a plenary action, we could subpoena that information quite easily, but we're not there, Your Honor. And frankly, the sale of the boat, it's not dispositive or it's not presumptive evidence.
I understand that, the sale of the boat. Now, I hear your argument saying, look, we still have the contract, but where's this boat now? Do we know where this boat is? Do we know where it's operating?
We believe it was operating within the non-attainment area designated by the contract.
How do you know that? How do you know that? Because you can't even get the purchaser to cooperate. So how do you know that? Where is this boat physically now?
It's a good question, Your Honor. And if we were in discovery,
it's not a tiny boat. You can't hide it, right? I mean, it's got to be pretty. You got to see it, right?
Yeah, sure. I mean, it's understood, but I personally haven't searched for the boat. And being the action was brought under this vehicle, we've opposed the motion and appealed And
That's
without,
like that's like an elephant in the room, man. I mean, you're saying that you don't know where the boat is. So come on. I mean, you have no idea. You have not that you don't know where the boat is, but you have no. There's no information on the whereabouts of the boat.
we could get it, Your Honor, just not in the context of a 3213 motion for summary judgment in lieu of complaint. With all due respect, I'm not trying to be disingenuous with the
No,
court.
I'm not. No, I'm not. I'm not. Don't, please, I'm not insinuating that at all. No. All I know is that the Port Authority is out 180 grand and wants his money back. That's pretty straightforward, I think.
But they haven't proven entitlement to that.
Okay, I got it.
There's still questions of fact which could be answered in discovery.
Got it.
That's our position, Your Honor.
Okay. Thank you, counsel. Thank you both.
Thank you.
Next case is Schwalbe versus Barahama. Step up, please. Or unmute your mics. Mr. Saad?
Yes, Your Honor.
Okay, you can begin.
Thank you. The July 11th court stipulation, to the extent that it's enforceable, provided for a hearing on the summary judgment motion if there was a default.
You know what? It did, and there was a default, right?
Correct. We cannot dispute
Right,
that.
and then the parties came in front of the court in August, I think August 15th, right?
Yes, Your Honor.
And didn't the parties change that July 11th stipulation? Wasn't there agreement at that time that your client, who really wasn't entitled to more time to pay, would be given more time to pay, and in exchange, if there were another default, that the plaintiff could enter judgment on the settlement amount? Isn't that what what was agreed to at that time?
Well, Your Honor, I don't believe so. I think that what was agreed to on that time was a new payment schedule. But Mr. Sizik, I believe.
Under what circumstances? Didn't it provide for the entry of a judgment under the settlement, an acceleration and the full amount? In fact, that was the consideration. Why would the plaintiff give you more time to pay out otherwise? They could have gotten the same thing on July 11th.
Right, Your Honor. I think that the reason why more time was given, the entire case, if you look at the entire case, these were high school or college-age friends. These are men who are now in their 50s, have been friends for 30 years. The plaintiff wanted to give.
I actually think that's irrelevant. So I mean, it's nice, but it doesn't really define their legal relationship. You know that.
Correct.
Well, they were friends. They were friends, I guess.
They definitely. I agree with that one too, Your Honor.
We all can agree about that. No dispute there.
I believe that the gift of the extra time was exactly that, a gift. It was voluntary. I don't believe it was an exchange of consideration, a quid pro quo. That there was additional time given to allow the defaulting brother, Eitan, to find money to pay. He never found it, of course.
Can I ask a question? So what? But they did agree to quote unquote acceleration. What sense did acceleration make if in fact they were really operating under the terms of the July 11th agreement?
Your Honor, I don't believe that Mr. Sizik really agreed to acceleration. This is what the court understood, and this is what Mr. Ravala, counsel for the plaintiff, understood. But I don't think Mr. Sizik agreed to acceleration, Your Honor. As I read those transcripts, I was not there. I read those transcripts, Mr. Sizik was fighting vehemently throughout the August court date and the September court date to say this is not supposed to result in monetary liability for not time. It's only supposed to be for a time. The additional time was to try and get things together so this matter could be resolved. But I don't believe there was ever an agreement by my client's former counsel to impose monetary liability on my client. There was no hearing for summary judgment. That is unambiguous in the July 11 agreement.
Counselor, this is suggesting. Let's just go back to the basics. Let's go back to the July agreement. Who are the parties to the July agreement?
On the face, unquestionably, my client was the defendant. The stipulation was entered in the case against my client. And I can certainly understand why an objective reading says my client was the party obligated under the stipulation.
It's an acknowledgement that your client was the party to pay under the stipulation. And there's a further acknowledgement that there was a default. He was given additional time. and there was a failure to pay under the stipulation, and the court entered judgment. Isn't that basically what happened here?
No, Your Honor, I don't believe that's what it is, because what happens on July 11th, we were supposed to go back to summary judgment. Look at the July 11th transcript, says unequivocally, if the first payment of $5,000, I'm reading page A121, and the second payment of $40,000 isn't paid, we'll have a hearing on the pending motion for summary judgment by the plaintiff on August 15th. That didn't happen.
You have a hearing? You had a hearing? You didn't?
No, Your Honor. The word summary judgment was discussed. If Your Honor will look at the September 26th hearing, it's on page A135 and 6. The court gave counsel for the plaintiff a choice. You want summary judgment or you want an accelerated judgment? Mr. Ravala, on behalf of the plaintiff, chose the accelerated judgment, which is not stipulated to. And in our contention, Mr. Cizik, prior counsel, did not agree to that either. So it's our position, Your Honor, that we did not get the benefit of our bargain. Our bargain, what we had was there a default that's supposed to go back to hearing for summary judgment or return to the case? One thing Your Honor did ask me about whether my client was the party to that stipulation. If we look at, I would contend, and the alternative argument is that the July 11th stipulation was ambiguous, enabling the court to view either not enforce it as an ambiguous agreement or secondarily to look at parole evidence. The parole evidence certainly suggests that the party...
Who could be a party to the agreement? The parties were settling. Your client couldn't bind his brother who wasn't a party.
I agree with Your Honor.
There was nobody to bind but himself.
Right. It's my understanding that...
I think the argument, respectfully, is ridiculous that your client wasn't bound by at least the July 11th agreement.
Okay,
it's sophistry.
Okay. If Your Honor sees it that way, I don't necessarily agree, but I'll accept Your Honor's point.
Clearly you don't agree. Yeah. All right.
Another issue raised here, Your Honor.
You're almost out of time, so I'm going to ask you to finish up your thought.
Thank you. Stale claims. The plaintiff in his complaint acknowledged that this was the November 2010 payment. In the motion for summary judgment, stated under oath that the payments were actually to 2008, 2009. These were stale claims when they were sued. The court has the power, implicit power, to amend the pleadings to the proof, and I didn't move for that here directly, but the plaintiff moved for that relief for summary judgment, point 5 of their brief. The court should, I was submitted, have the power to therefore search the record and take this conclusive judicial admission that these claims were stale. And
I think we understand. Thank you. You're out of time. Mr. Ravala.
Good afternoon, Your Honors. Salman Ravala for Respondent Jason Schwabe. We believe the court's analysis at this point is correct. Our brief outlines our arguments, and the court essentially has stated so in its questioning of the appellant. What I'd like to...
July 11th agreement, it did say if there were a default on the beginning payments, that your client's remedy would be that the parties would go back to have a determination on the underlying summary judgment motion, correct? That was what was agreed on July 11th.
That's correct, Your Honor.
All right, so what changed?
What changed?
What changed after July 11th? That the agreement changed from an agreement that a default would trigger a decision on the underlying summary judgment motion to a determination that they were in default under the payment stipulation.
It's our position that not much changed. In fact, on August 15th, the appellants attempted to renegotiate the terms of the agreement. Acceleration was a condition that was added, and thereafter, the court entertained the idea of entertaining an oral application, and thereafter, appellants requested a hearing on the motion for summary judgment. That motion
but the summary judgment motion was never heard, never decided. Never decided. The motion for summary judgment was never decided.
It was never ruled on, that's correct, but it was heard in our position. And the court offered two positions.
But it was never decided, right? Instead, you got judgment on the agreement.
We believe that that's correct, but just to clarify, the court offered both parties two options. One was a decision in favor of the respondent on the summary judgment, or the other option, which was the judgment. We chose to do the other option, but the transcript's fairly clear that the motion for summary judgment.
What sense does that make? Is that legally permissible? The judge could give you two options. Doesn't the judge have to make a decision based on the law? Either you were entitled to a decision on either the summary judgment motion had to be decided before the court, or no, the issue before the court was enforcement of the settlement agreement. Which was it? Can't be both.
Well, just to clarify then, it was two separate applications. The motion for summary judgment was before the court from November, correct? So that's one application. The other application was...
But if you settle a case, you don't get summary judgment on it.
And that's exactly...
It's enforcement of the settlement.
Right, and that's what happened here.
Yeah. Okay. Any further questions, counsel? Colleagues? Okay. Thank you, Mr. Ravala. Mr. Saad, you have 2 minutes rebuttal.
Thank you. On the settlement agreement, I agree with Your Honor's questions to Mr. Ravala. We were entitled to a hearing on the motion for summary judgment. I agree with the statement.
There's nothing to agree. I asked questions. I didn't give answers.
I was going to correct myself that, Your Honor, I agree with the statement underlying the questions that we were entitled to a hearing for the motion on summary judgment, and we did not get it. That's the reason why I believe this matter should be vacated. The judgment should be vacated and be remanded to the trial court for all purposes.
But when they talked about acceleration, that you could only get under the settlement agreement, correct?
Correct, Your Honor. And I believe that is
correct.
But
you claim that there was no agreement on acceleration. I'm not sure I agree with you on that, but, that's for us to decide.
That's correct, Your Honor. That is our position. There was no agreement on acceleration.
Okay. Anything further?
No, Your Honor. Thank you very much.
Thank you, sir.
Question, may we then leave this meeting now, since we're finished today? We can end this.
I don't require your appearance.
Okay, thank you.
Thank you, Your Honor.
Minor versus East Harlem tutorial.
May it please the court, my name is Marcy Sonneborn for the appellant, East Harlem tutorial. The plaintiff was a security guard at East Harlem. She sued the school when she pivoted on a short staircase of 4 risers, missed the last step, and fell. There is a live video of the incident which shows the plaintiff standing sideways on the steps, speaking to her coworker, pivot, miss the last step, she was 1 step from the bottom, and fall.
Counselor, this is Judge Singh. Counselor,
yes.
Is there an issue of fact as to the stability of the railing? We've all seen the video and we can make up our minds as to what it shows or doesn't show. But with respect to the railing, did the plaintiff testify that the railing was shaky, defective, something which caused her to fall?
Respectfully, she did not testify to that. Her attorneys claim over and over and over again that the handrail was loose. But in fact, when the plaintiff was deposed, she was repeatedly asked why she fell, and she repeatedly gave as an answer, the steps were slippery, period. She said that the silver tread on the steps was slippery. Later on in her deposition, after she was shown the video, she's asked about the handrail because her bill of particulars does make a claim of a loose handrail. And she's asked about her handrail. And it's with respect to an affidavit that she submitted from her friend, Pedro Ramos, who she brought to the school about a month after the incident. And she had him submit an affidavit which said the handrail was loose. Now, 2 things about this. The first, well, 3 things actually. The first is it's a month after the incident. The second, perhaps the most important, is Mr. Ramos said the middle handrail was loose. But the handrail that the plaintiff was holding onto was the handrail that abutted the security desk. And when she was asked about her friend's affidavit and asked about how she fell, and I'd like to read from the record from her deposition on page 159. And she's asked, what did you show him? Him meaning Mr. Ramos, a month after the accident. And she says, I showed him exactly how I slipped and fell off the silver tread. And this is after pages and pages of testimony that she fell off the silver tread because it was slippery. And the question is, what about the railing did you show him? And she said, I showed him how I grabbed onto the railing and how it did not support my fall and how I slipped off the silver tread. It is slippery all the time. Question, did you show him that something was wrong with the handrail? Answer, no. I told him that it didn't support me. I told him that it was very weak because it did not support me. Her claim, her sole claim about the handrail is that she was holding on to it, but she fell anyway because she pivoted, she missed a step. That is shown on the video. And by the way, her coworker, who was seated at the security desk watching her fall, said the exact same thing when he was deposed. She missed the last step and she fell. There is nothing at all about the handrail being loose.
Counselor, didn't she also say that the handrail was off balance and it was vibrating, or words to that effect? Is that enough to raise an issue of fact?
Respectfully, no. For a number of reasons. Number one is that this was a brand new school, 5 months old, received a certificate of occupancy. Everyone who was at the school who was deposed submitted affidavits, the director of operations, her coworker. I used the handrail every day. There was nothing wrong with it. There were no prior complaints, no subsequent complaints, no prior repairs, no subsequent repairs. There's affidavit testimony from the current director of operations, the director at the time of her accident. This handrail was never repaired. Nothing handrail.
This is Judge Mendez, counsel. Didn't the plaintiff herself say that she complained at one point about the handrail being wobbly, being loose?
So, yes and no. The plaintiff said, now the plaintiff was a security guard. It was her job to submit complaints in writing via an email to the director of maintenance or via the logbook at the security desk. She admitted she did neither. The plaintiff claimed she wrote on a sticky note, which, by the way, nobody saw. There's no corroboration at all of this testimony. She claimed she wrote on a sticky note that she had a complaint about the handrail. But again, this is in the face of the testimony of the director of operations. I use that handrail every day, morning and afternoon, for the 5 months since the school had been open. There was nothing wrong with the handrail. And the subsequent director of operations, the handrail was never repaired. And the video, which does not show the handrail appearing loose, it's as though a plaintiff or any party could say anything. If a party says the sky is black and has no evidence of that, does that raise a question of fact? This is complete speculation. She doesn't even say in her deposition that the handrail was loose. She said it didn't support my weight. It's a brand new handrail. And we brought in an expert engineer.
The handrail that she was holding on to when she fell was the handrail that was abutting the reception desk. Is that correct?
That is correct.
And was it attached to the reception desk? It was hard to tell from the pictures just if there was any space between the handrail and the reception desk at all.
Well, it appears from the photographs that the handrail is on the wall, and the wall creates what appears to be a cubicle that houses a reception desk. So if you look at the photographs, I can direct you to page 369. It shows you walk into the school, the security guard who sits at the desk walks to his desk, sits down, and then there is a wall and 4 steps going up to the lobby, and that is where the handrail, which abuts, that's, you know, closest to the security desk is.
And one other thing, if you could just address the claim made by your adversary that as part of your prima facie case, you should have addressed their issue about design defect.
Yes, thank you. So if you look at the bill of particulars, it is a boilerplate bill of particulars that could have been picked out of any slip and fall on steps. In fact, we found some details in there that had nothing to do with this case, as though it were picked off of another case. It is boilerplate, it is generic, it is general. Nothing is said about a design defect. East Harlem moves for summary judgment. We have a ton of evidence, brand new school. We had an affidavit from the flooring subcontractor that a non-skid surface was used. There was abrasive nosing on the treads, code compliant, industry standard. We have affidavits, deposition testimony from the people who work in the school, from her coworker. Everything is great. Now, there is nothing at all about a design defect, nor does she testify to that. Now, in opposition to our summary judgment motion, the plaintiff says for the first time they bring in an expert who never visited the school. And the expert says, without visiting the school, it is a design defect because she had to stand on the steps to talk to the security guard, to talk to her coworker. Well, if you look at the photographs, you can see that's not true. Look at page 369, 370, 371. Look at 313, which is the photograph she identified at her deposition. It's not as quite as clear as the one on 369, but it shows you enter the school and you can stand and address the security guard at the security desk before you go up those stairs. There's no reason to stand on the stairs to talk to the security guard at the security desk. It's truly hogwash. And in fact, the lower court said if Joe is standing sideways on the steps talking to the security guard at the security desk, he's going to fall. But the fact is, because they raised this and brought in an expert in opposition to our motion for the first time, we hired an expert. And the expert said what the photographs show. There's no design defect. So the plaintiff objected to that, and we obviously object to the fact that the claim was even allowed in opposition. But more important, look at the photographs, look at the video. You can stand directly at level ground and address the security guard at the security desk. She stood on the steps, she faced sideways, she missed a step, and she fell. The video shows it, her coworker testified to it, the photographs show it.
Okay, thank you.
Thank you.
Ms. Hutter,
Yes, Your Honor.
you may proceed.
Thank you. May it please the court, Barbara Hutter for the plaintiff respondent, Ms. Minor. We are asking that this court affirm the lower court decision that denied summary judgment to defendants. And it's because the exact reason that issues of fact actually exist.
Okay, Ms. Hutter, this is Judge Singh. Let me stop you there. And the same question to you that I asked your adversary is, what is the issue of fact with respect to the stability of the railing?
Sure.
From the mouth of the plaintiff.
Yes, I can. There is absolutely testimony in her EBT where she talks about how the railing impacts
specifically.
Yes, I will point you.
What specific testimony is there on that point? She says the handrail was off balance. It was some sort of vibration. What more? That a simple statement.
Yes,
the handrail was shaky, and as a result, I lost my balance and fell. Something like that.
So, in In our original papers, which lays out part of the testimony because it's in several different parts, on page 331, the question to her is, what point did your foot slip? She said, when I was stepping down, I was still holding to the railing. Now I slipped directly off the silver thread. I am holding onto the banister, and because it is weak, it did not support me how the banisters are supposed to.
But what does that mean? Weak means
Well,
that
she
it
goes-
collapsed?
Meaning
Is it
that it's, so she's also goes on to say that she continues to hold it and that the railing itself did not break her fall. And they
Counsel,
said,
okay,
and
counsel,
so, yes, Your
counsel,
Honor.
this is Judge Owing. I'm sorry to interrupt you. But right there, when you say that the banister or the railing was not sufficient to support her, I'm watching the video and I'm watching it very carefully. She takes a misstep and her whole momentum is going forward. So whatever rail you had, whatever handrail that exists there, unless it's really wobbling and it's not stable, her momentum itself is going forward. Unless I'm looking at the wrong video, there's just nowhere for her to grab on. I mean, she's grabbing onto, but just by sheer momentum of the way she's going, I mean, that's just simple physics. She's not going to be able to hold on because she's going one way.
But she also,
to add to that, counsel, when you look at the video, you see that her arm is not in front of her, but behind her. So to add to what Justice Owing just said, how could she hold on to the railing when her weight is in front of her and her arm is behind her?
That's physics.
It's physics.
But I think
Plus, we got a different law of physics here going,
I think what both Your Honors are pointing out is really still a question for a jury to decide and not for this panel to decide. And that's what the trial court had decided, that there's still enough testimony from her.
That's not what your expert put forth, though. Your expert didn't say that didn't mention about how the physics and how her momentum is going one way, her arm's going another way. Didn't they make any commentary in the expert affidavit saying that, yeah, you know what, even in those circumstances, she fell because the rail was not stabilized, was not stable. He didn't, I'm just looking at that. And that's the first thing I'm looking at is like her weight's going one way, the hand's is in the back of her. The expert could see that, and obviously he did because he wrote in a report about watching the video. Says, you know what, even with all that, she would not have fallen if that handrail was attached properly.
But I think her accident, Your Honor, is really a combination of a couple different things. Yes, her momentum.
One is looking at her foot. She did take a misstep. She looked like I'm watching that really. I hit a slow-mo on that one too, and she missed the step.
So, but part of our argument is that the whole positioning of placing the security guard directly with the rise of the step caused her to be in this conversation with him.
Okay, let me, Counselor.
No. Okay, I think Justice's going to ask the question.
Counselor, let me just stop you for a second. So essentially, you're arguing a design defect, correct?
It's more distracted focus, and the layout causes that distraction.
But that's a design defect. I mean, you can call it anything you want. Layout, it's a design defect. Is there an allegation in your BP with respect to the allegation, the argument you're making now, that the layout was such that there was some kind of defect which was a proximate cause of her injury?
Well, I think you have to look at all of the pleadings in order to flesh it out.
Okay, in all of your pleadings, is there any kind of assertion like that?
Yes, it talks
other than your expert's affidavit.
In our pleadings, give me 1 second, we have it where it talks about that the defendants are in charge of maintaining the common areas, including the stairwells. It talks about improperly constructed, unlevel areas. It talks about allowing the stairwell to be remaining in a dangerous and defective condition.
Counsel, this is Judge Mendez. Isn't that boilerplate language that goes into just about every complaint?
But pleadings are allowed to be broad, and
precisely. And then
yes.
Isn't it in your bill of particulars that you're supposed to particularize what exactly it is that you're trying to say in your complaint?
And we did, but we also, again, is able to be
Where
amplified
in your bill of
by her
particulars do
testimony.
you allege design defect?
It's in those words, Your Honor. We might not have put the exact
Let
term
me be,
design.
I just want to, if my colleague would let me, I want to add to that question. Not just design defect, but a design defect regarding the placement of the reception desk. Because that is what your expert is claiming. It's not just quote unquote design defect. Because that doesn't give anybody notice of anything. You need to particularize that it had to do with the placement of the or design of the reception desk.
And as the trial court recognized, Your Honor, and as this court has recognized, that those pleadings can be amplified through testimony and the affidavit. And that is how you put it all together. Because again, it's not just one particular aspect that's causing her to fall. It is this idea that the way it's constructed and the way she has to turn her focus from being sideways towards the security guard and then going towards the front.
Counsel.
Another thing about your claim of design defect, because I read your expert's affidavit, and what was missing that's usually or necessary in a design defect case is that your expert has to give the standard, the building standard, the design standard from which this deviated, and there's nothing in there other than it's just his opinion, and I don't think that that's actually sufficient. I think that he has to say that there was a building that at the time they were constructed, there was in fact a standard that was used in the industry, and he didn't meet that standard.
But again, I think all of this points to questions of fact, that when you put it before
I don't know. I think you have to do more than that. I'm going to ask you to wrap it up, though, because you are out of time.
I would just, Your Honor, I do think the last final part is there was notice given. The defense counsel keeps ignoring the fact that Ms. Minor did tell Mr. Alvarez, who was the head of their maintenance, in a verbal conversation, and that fact has never been disputed by any testimony or any affidavits. We've given notice.
But if there's no dangerous condition, then in fact, then in fact the notice is meaningless, right?
There is a dangerous condition. And I think you just have to look at it in totality. Yes, of course, that's for what you have to decide.
That's a matter of law, right? You agree with that? That's a matter of law, what I just stated, right?
Oh, yes, okay. Your Honor. That at the end of the day, though, my final statement, Your Honor, is that we have to affirm the judge's decision.
Thank you. Ms. Sonnenborn, you have 2 minutes.
I'm going to take half a minute. I'm going to ask the justices to look at page R370. And this photograph is worth 1,000 words because you can see there is no design defect. You walk in, there is plenty of room to stand at that desk before you go up the steps. The notion that she had to stand on the steps and face sideways is absurd. This is what the brand new beautiful school looked like.
And that's not where the guard was at her accident.
All right, any further questions, colleagues? Thank you.
Thank you,
counsel. Thank you both. People versus Perez.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Jose Perez.
You may proceed.
Thank you, Your Honor. The resentencing court failed to adequately offer Mr. Perez an opportunity to withdraw his plea, where it didn't so much as mention plea withdrawal before imposing an enhanced sentence that...
Does it matter that he was represented by counsel at those proceedings?
No, Your Honor, that's not relevant. We're not.
So there really is no dispute. He did have the right, if he wanted, to move to withdraw the plea, right? That's
correct, Your Honor.
Right. So the issue that you raise really is, did the court have to tell him at the time of resentencing that he had that right?
That's right, Your Honor. And the case law makes perfectly clear that the court did have that obligation. When the court...
And I'm sorry, Counselor, what case are you relying on for this proposition? Is it Franklin?
Primarily Franklin, Your Honor.
Okay, so how are the facts of Franklin similar to the facts of this case?
They are, in every relevant respect, identical. In Franklin, it's a Sparber resentencing. The defendant is given a general opportunity to raise objections to the enhanced sentence, but never told about plea withdrawal. On appeal, he argues that he was entitled to more of an opportunity to withdraw his plea.
So let me stop you there for a second, Counselor. So defendant objected to the enhanced sentence, correct? Your client didn't object, but he consented. And later in Franklin, when the court gives its reasoning, it says, since the people insist that post-release supervision be added to defendant's original sentence, defendant must consent or be offered an opportunity to withdraw his guilty plea. Didn't he have that opportunity here?
Let me take those points in turn, Your Honor. He had the exact same opportunity as Franklin, Mr. Perez did. No more, no less. The defendant in Franklin did not ask for plea withdrawal. He raised a double jeopardy objection to the imposition of PRS at all. And it would be very strange if, in order to preserve a claim that you were entitled to plea withdrawal because of an enhanced sentence, you had to raise a completely separate argument based on a completely separate body of the Constitution asking for different relief. That is completely contrary to all of this court's preservation jurisprudence. And the court in Franklin never gave any indication that that objection is what triggered the court's duty to offer him plea withdrawal. And I think if you look at the prosecution's brief in Franklin, which we cited in the motion court and we cited in this court, the prosecution is raising the identical argument. They're saying the resentencing court has no affirmative obligation to offer the defendant plea withdrawal. The onus is on the defendant to make that motion himself. The third department properly rejected it. And I want to direct your honors as well to People v. Bonilla, which we cited in our reply brief. That's a first department case. It's outside the PRS context, but the court imposed an enhanced sentence. This court reversed that sentence and remanded for the defendant to be given an opportunity to withdraw his plea, despite the fact that, this is a quote, neither the defendant nor his attorney objected to the sentence imposed. That's because the court, when it takes on this affirmative step of imposing an enhanced sentence, it has a correlative duty to offer the defendant the opportunity to withdraw his guilty plea. And unquestionably, Mr. Perez was never told that by the court. I'd also point out nothing indicates that he intentionally waived this right. Again, plea withdrawal is never mentioned in the course of these proceedings. Mr. Perez hardly says anything on the record. He never says anything approaching, I don't want my plea back. And counsel doesn't say anything like that either. All counsel says is, we're not in a position to file papers at this time. And I think in the context of this transcript, it's quite clear that what counsel is...
But beyond that, Counselor, just reading from the transcript, defense counsel also says, corrections administratively added the post-release supervision. I think defendant is prepared to accept the amended sentence. So doesn't that tell me that counsel had a conversation with his client, the defendant? The defendant had about a year left on his sentence. He was explained what the consequences were, that if he withdraws his plea, he could may get a longer sentence if he's convicted, et cetera, and defendant made a rational choice at that point to take the PRS.
No, Your Honor, absolutely not. All that it's indicating is that counsel is saying he doesn't have a legal basis to challenge the imposition of that sentence. He doesn't have a double jeopardy challenge to the sentence. And I think if you look at what the court says in response to that, well, right, he's still serving the sentence. He's still incarcerated. What the court is talking about is double jeopardy challenge to the imposition of the sentence. No one was talking about plea withdrawal here. And I think if you look at what the court says, it makes quite clear that everybody thought this was mandatory. The court says it's already been imposed by the Department of Corrections. It's mandatory. That's all implying there's nothing the defendant can do at this point.
This is Judge Owing. I have a quick question. How much time did he have left when this was coming down?
I believe he had about a year left.
Yeah, about a year left. Okay,
I believe so.
okay.
And what was counsel, this is Judge Mendez, if he withdrew his plea and then got convicted of this crime, what was he facing?
I'm not 100% sure what his sentencing exposure
But it was a lot more than a year, correct?
Sure, it was. But again, respondent has never alleged that we need to show that he would have actually withdrawn his plea. And this brings me back to Franklin. It brings me back to Bonilla. In order to establish that the defendant is affirmatively...
You know what, your arguments, counsel... I'm sorry.
Sir, would he have had an ineffective assistance of counsel or argument if his attorney didn't tell him about that alternative at the resentencing hearing?
He may well have, but the court also had a duty to advise him about plea withdrawal, whether or not counsel was effective. In order to establish that Mr. Perez was waiving this right that he was entitled to, the court needed to ask him, do you want to withdraw your plea? This was not an onerous requirement. This is exactly what Franklin held, is that the court has an affirmative duty to, when it's taking an affirmative step by invalidating the plea retroactively, by enhancing the sentence.
But that affirmative duty comes at a situation where I think the facts borne out or cry out for the court to do something. When you have defense counsel making these representations, I mean, the trial court just go ahead, does it. Okay, be that as it may, that's what happened here. But, reason I asked about how much time he had left, he has a year left. I mean, that feeds more into a 440 situation, because then I'd like to know exactly what did counsel talk to defendant about in terms of the ups and downs, the benefits, and the risks of vacating the plea. That's where it sounds like these arguments are going. But that's just me.
Respectfully,
I disagree with that.
I disagree.
I'm going to ask Mr. Weiner to finish up because you're out of time.
Sure, Your Honor. I would just say Franklin is clear on this point, Bonilla is clear on this point, and it would require disagreeing and overruling with those cases to rule in favor of the prosecution here. Thank you, Your Honor.
Okay, Ms. O'Shea?
Oops.
People versus Perez? Sheila O'Shea? All right, Mr. Weiner, what I'm going to do is I'm going to recall this at the end of the calendar because Ms. O'Shea was here and perhaps she had some technical difficulty. So we'll give her an opportunity and we'll give you your rebuttal if you don't mind. Thank you.
Thank you, Your Honor.
All right, let's call up Navarez, People versus Navarez.
May it please the court? My name is Abigail Everett for Appellate Milton Navarez. Your Honors, the defense lawyer below told the judge that a prominent psychiatrist had assessed Mr. Navarez and was of the opinion that he was a malingerer. This statement revealing confidential information was good cause supporting Mr. Navarez's request, his persistent request to have a new lawyer assigned to represent him. If you take a look at the record as a whole, you can see that the assigned counsel in this case was persistently taking positions that were adverse to positions being put forth pro se by the defendant. For example, in June, when the defendant made his motion for a new lawyer, the defendant really had two legal positions he was advocating on his own. He was arguing that he was not competent to go to trial, that he had psychiatric difficulties, and he was arguing to the Judge Biden that she should offer him a lower sentence, which she had the power to do. The judge was already making an offer without the DA being involved because she was offering 30 to life, which was below the DA's position, but she could have offered 10 to life. And the defendant, pro se, was trying to convince the judge that because of his psychiatric difficulties, she should show some mercy to him. In this context, assigned counsel, that's the first time he came in and said to the judge, look, Your Honor, and in fact, he interrupts the defendant while he's trying to make this pro se plea. And he says adversely, look, what happened was legal aid, who had the case before, hired a prominent, impartial psychiatrist who assessed the case and said he has no insanity defense.
Counselor, this is Judge Singh. Just refresh my recollection. Didn't the judge essentially reject this claim with respect to mental impairment?
Well, yes.
Based on the judge's observations of the defendant?
Well, this came up repeatedly during the case. Now, at one point in the fall, in October, and I point out that the defendant repeats his request, June, August, September, October. In October, I believe, Judge Biden did say, look, as far as I can tell, he doesn't look to be incompetent, but, we've got another 5 weeks here. I will order at 7:30. Now, this is what the defendant wants. That's his position. And then that's at the point where the lawyer comes in and says, Your Honor, I had this prominent psychiatric opinion that he's a malingerer. So even if the judge's perception at the time was probably a 7:30 wasn't necessary, she was willing to offer it. And this is what the defendant pro se was advocating for. So for the lawyer, the assigned counsel, to take this adverse position to say, look, this is totally unnecessary, Your Honor, he's a malingerer. I think that that's pretty clearly good cause for letting Mr. Narvaez have a substitution of counsel. And in fact, that's
and one more question.
Yes.
The applications, at least to my mind, appear to be made at eve of trial. Am I wrong about that?
Well,
and if in fact they were made at eve of trial, doesn't the court have discretion to proceed based on this belief, in fact, that there was essentially an attempt to delay trial?
Well, I have two answers. First of all, it's pretty clear in June, when the issue was first litigated, that it's not the eve of trial, because at that very appearance, the parties have already decided it's going to be adjourned for 3 months to September 2017. So that's at the point when Judge Biden is first being asked to consider whether or not a new lawyer should be assigned. So I would submit that that's really not appropriate to say that's at the eve of trial, even if at the prior appearance there had been some discussion at the suppression hearing that they were going to go to trial. And yes, there had been discussion along those lines. But by the time this issue is being discussed on June 27th, everybody's already decided it's going to be put over 3 months. So I'm not sure that's really appropriate to designate as the eve of trial for that reason. And I would submit further, of course, by the time they get to September, the DA's not ready, and they've already agreed it's going to go over to October. When the defense lawyer makes his statement revealing that the psychiatrist has determined he's a malingerer, I would say that even if that happened on the eve of trial, that's such a significant revelation in violation of the lawyer's obligation to confidentiality, that in and of itself should have been granted, even if it were to be designated the eve of trial. I think that's such a significant inappropriate behavior by the defense lawyer, because we have to remember now Mr. Narvaez has to go to trial with this person who's already said, look, Judge, he's a malingerer.
Well, but that's a little unfair, isn't it? I mean, that's what the expert purportedly said.
It's not gospel. That's what one expert reviewed and said in that expert's opinion he was a malingerer. This is not a situation where a defendant had admitted to his lawyer, I'm going to lie. Yes, there was an opinion by one expert that he
and that's all the counsel was doing. Counsel was relaying what the expert said with respect to his client, correct?
Well, first of all, we don't concede that that's what the expert actually said, but the lawyer had no business revealing that information. It's one thing for the lawyer to say to Your Honor, I don't support his pro se request for 7:30. I don't support his request for, I'm not joining for the counsel. I don't agree that there needs to be an insanity defense put in. Those are all neutral differences of strategy that the courts have looked at, and it's appropriate for the judge to consider in trying to decide if a new lawyer needs to be appointed. I argue that this is really different in kind. This is the revelation of a confidential opinion. And the lawyer was very detailed. He talked about how there were allegations the defendant had drugged one of the children and how that would be inconsistent with an argument that the defendant had not had intent to commit the crime. This is far beyond
one of the children were asleep when these crimes occurred, right? Or were unconscious?
Yes.
So there is a basis for that, no?
There is a basis for that, yes, but I think that it's also clear that the lawyer is taking an adverse position to his clients. And I would ask Your Honors also to consider this kind of constant little comments that this lawyer is making. I've tried to put these out in my brief. Statements like, you know, oh, yes, such videos there are, and his, I don't want to take it out of context. I think he said his.
So do his comments, do they?
He sees it. I'm sorry.
Are the comments such that maybe you have an ineffective assistance claim here?
I think the comments are, they make the record as a whole support the argument that there was a good cause to grant his request for a new lawyer. This is not like a 440 situation where Mr. Narvaez is coming in after the fact and trying to ask Your Honors to find this stuff. He's making his personal, this record is being made as it goes on, and he's persistent about it. This lawyer, that there are irreconcilable differences, that he doesn't want him to do it, that they can't communicate. And so for that reason, I think that the judge, I submit that the judge erred on more than one occasion in denying. For example, to give you a flavor of this, there's the incident where he's being brought into the courtroom and he falls on the floor in the elevator. Okay, instead of having the court officer report what had happened and let the judge make a determination, let Judge Hong make a determination, the defense lawyer says to the judge, I was there, he falls on the floor. As soon as the court officers made it clear they weren't bringing him to the courtroom, he pops back up. Now, obviously, he's undermining his own client and making it clear.
Hold on a second. This is Judge Owen. Hold on a second. I mean, I don't think that the defense counsel is volunteering all of this information without the proper inquiry. I suspect that the trial judge was making inquiries where he's asking certain things and defense counsel is offering up the explanations. I'm not so sure. You're giving me the impression that he's charging into the courtroom and just literally throwing his client under the bus.
Well, let's say he's not reluctant to throw his client under the bus.
Yeah, but the way you play it out, it's more like he's just literally tossing him out into the sea. I mean, I think it's a matter of the dialogue going back and forth, and things are happening rapidly and very quickly. So I just want to make that point.
I'm trying to submit the record as a whole to support what I think is the main argument.
And this is his third attorney too. Let's not forget that fact. This is his third attorney that he wanted to change out again.
It is his third attorney, but I submit that when he tells the judge that a psychiatrist called him a malingerer, essentially called his client that an expert had determined he was a liar, that puts the situation in a whole new light, that this is such a significant revelation of confidentiality. Just briefly before I lose my time here.
You've already lost your time, but I'll give you another minute.
Okay, sorry. I finished then.
Oh, okay, thank you.
Justice Gish, I'm very sorry to interrupt you. I'm Sheila O'Shea, who was here for the Perez case. Unfortunately, when I went to unmute my microphone, I got kicked off the call.
I indicated to counsel that I'll call you at the end of the calendar.
Okay, thank you. I just want to let you know I'm
here. Thank you. All right, Mr. Kress?
Yes, thank you, Your Honor. Okay. Good afternoon.
Good afternoon.
I'd like to pick up on a point that I believe it was Justice Singh who raised about the request coming on the eve of trial. So the case law, and we cited in our brief, says pretty clearly that there is no good cause for substitution of counsel if a request for new counsel is a delaying tactic. And obviously one of the things that you consider in determining whether a request is a delaying tactic is the timing of it. And in this case, the defendant asked for new counsel for the first time on June 10th, 2017. At the time he made that request, for all that he knew, trial was starting 17 days later on June 27th. At the previous appearance before Judge Ward, she had said, I'm setting a firm trial date, June 27th. So when he makes this request, there's no indication to me that anyone had agreed to put off the trial at that point, or at least, or that he would have any reason to think that. The only thing that we can conclude from the record is that he thought trial was starting 17 days later.
Counsel, I'm sorry to interrupt. This is Judge Oren. What's your response to the appellant's counsel's claim that the defense counsel, by calling him a lingerer, is essentially taking adverse positions against his client and looking at the record, literally throwing him out to sea without a life jacket? How do you respond to that? Because that's her argument is very clear. By calling him, by telling the judge that a psychiatrist or a doctor or an expert had deemed him a malingerer, that was inappropriate. He crossed the line.
Okay, so let me make 2 points in response to that. The first is that, as this court has said, even if you assume that an attorney takes an adverse position, if it doesn't influence the court's decision on an application in some way, then there is no reason to appoint new counsel. That's the Burgos case that we cite, and among others. And in this case, defense counsel has not pointed to a single decision that the trial judge would have made differently if defense counsel had not mentioned the comment about the experts finding that he had been.
Aren't they kind of tied together, though? The idea that I'm not going to give you new counsel because you're malingering. We got to get this trial done quickly. Well, isn't that? I mean, I'll grant you that they're not usually tied together, but it's hard to untie this bundle.
Well, so Your Honor, actually, at that let me make 2 points. The first is that Judge Bybin had already denied his request for new counsel in September, before this comment is ever made. This comment is made in an October 3rd proceeding. On September 5th, Judge Bybin said, I'm not granting you a new lawyer. This case is going to trial. Your lawyer is representing you effectively, so request denied. She makes the exact same thing. She says the exact same thing on October 3rd, before this comment is ever made. She says, you've submitted additional requests for new counsel. I'm denying them. And then afterwards, when the defendant starts raising issues about his mental health, Judge Bybin says, and this is actually very important, and another point I wanted to make, she says, look, you've raised your mental health. I defer to counsel on what he wants to do regarding that. And in other words, whether or not, he wants to have a 730 exam to try to determine your competency, I defer to counsel. So she's not saying, oh yeah, I'm going to order a 730 exam, and then counsel steps in and says, oh no, don't do that. She's saying, I leave it up to you. But then she says, she does ask him, do you want a 730 exam for your client? And that's when Mr. Katz gave her an answer. And he says, no, I don't think one's necessary. And he explains because the expert had evaluated him.
Hang on a second. Hold on a second. Don't you think that puts the defense counsel in a very untenable position when the court says, I defer defense counsel? I mean, don't you think, normally speaking, that defense counsel would jump at that and say, yeah, I want a 730. That's terrific. Yes, let's go for a 730. Instead, defense counsel says, no, we don't need it. He's a malingerer. I mean, that's what the appellant's counsel is. That's what the counsel's arguing, saying, I don't understand why he did that. At least that's what I think she's arguing. What did he do that for? The court's deferring to defense counsel. I would think defense counsel would say, if you're going to defend, I mean, if he's raising mental issues, putting aside malingering or not, okay, let's do the 730. Put this to bed.
I mean, I don't think he has an obligation to do something that he thinks is completely unnecessary. He owes a duty of candor to the court. He's not going to waste time and waste court resources. He doesn't have to take the court up on its offer if he doesn't think that a 730 exam is appropriate or necessary. Now, I grant you that he could have just responded and said, no thanks, Your Honor. I agree.
Could the defense counsel have done that for strategic reasons?
I'm sorry, done what, Your Honor?
Could not gone forward with the hearing?
In other words, declined a 730 exam.
Yes.
Yes, certainly. He could have done that for strategic reasons. And we don't know what those are. There's been no explanation or exploration of those issues. But I think the bottom line is that he gave an explanation to a question from the court. It wasn't unreasonable to, not just say, oh, no thanks, I don't need one, or no thanks, we don't need an exam. It was perfectly reasonable for him to explain why he was declining. And then I think the real bottom line is that it changed nothing. This comment absolutely changed nothing. There's no way that the court had not indicated that she was going to grant 730 before that, just for the asking. So it really has no effect on anything that happened. And I know defense counsel pointed out before at the June proceeding that she seemed to suggest that there was some hope that maybe the defendant would get a shorter sentence before defense counsel chimed in and said that he has no insanity defense. Judge Bybin made it very clear at the beginning of that proceeding, 30 to life was the offer. Take it now or go to trial. So again, the idea that whatever counsel said had some effect or some consequence is just not supported by the record. 30 to life was the offer. He wasn't going to get anything less than that, thank God. So again, there's no consequence to anything that counsel might have said. Unless the court has any other questions, I'll rest.
Do my colleagues have any further questions? Okay, Ms. Everett, you have 2 minutes.
Okay, Your Honor, in answer to the question about could it be strategy for denying for turning down the offer of a 730 hearing, wouldn't it have been more professional and not adverse to the defendant to just say, I'm not asking for that? Why does he have to then go and say, Your Honor, a prominent expert has determined that he's a malingerer? I mean, that's really above and beyond the question of strategy. So that if Your Honor feels that there might be a strategic reason, what the response from the lawyer really is not on its face a reasonable strategy. He could have just said, no, thank you, Your Honor. And again, this is a pattern in this case. It's obvious that these two people are working against each other. And this is one of many adverse positions taken by the lawyer to what the defendant is asking for. And I would briefly say, I know that the people strongly oppose this, but that the difference between 100 to life, which is the sentence that he was imposed, and the 30 to life that was being offered is excessive. I would ask Your Honors, even in this case, to consider exercising the court's discretion to modify the sentence closer to something. And perhaps
Counsel, let me ask you a quick question. I'm sorry to interrupt. Well, in the 100 years to life sentence, when's he eligible for parole?
100 years. It's 4 consecutive 25-year sentences to life.
So he's eligible parole. He's not eligible for parole in 25 years?
No, it's consecutive. The minimums run consecutive. He was a man of about 34 at the time of arrest. I think that the 30-year to life that Judge Bybin was willing to give him, I mean, if you read that aborted plea colloquy.
Counsel, this is Judge Singh. But there are consequences for going to trial, right? Let's assume prosecution agreed 30 to life and you're taking it. That's one option. But he believed something closer to 10 was appropriate. So he went to trial, and aren't there consequences once you go to trial, which is your constitutional right? And there's no suggestion here that this is an illegal sentence. There were 97 counts, I think, by my count, of some pretty heinous activity.
Yes, Your Honor. But on the other hand, we are talking about a 70-year, and I have to apologize for my math mistake in the brief, a 70-year difference between what the judge came very close to imposing and what he got after sentencing. So I did want to mention that before the argument came to a close. Unless there are any further questions, I'll rest on my brief for the other points. Thank you, Your Honors.
Thank you, counsel. Thank you both. Right, next, we're going to hear Guido versus Fielding.
Thank you, Your Honor. May it please the court.
Mr.
name is,
Scafaldi, right.
may it please the court, Your Honor. My name is Anthony Scafidi, and I represent plaintiffs' appellants. We submit that the lower court erred in granting the defendant respondent partial summary judgment on the issue of whether or not Dr. Fielding's failure to diagnose and repair the plaintiff's small bowel perforation intraoperatively on August 17, 2009 was a departure from good and accepted medical practice, and seek reversal for two reasons. The first reason, the defendant, as the proponent of the motion for summary judgment, failed to satisfy their burden, demonstrating entitlement to said relief. Second, even if the court finds they met their burden, a battle of the experts as to whether the plaintiff's small bowel perforation should have been diagnosed and repaired intraoperatively precluded summary judgment.
You know, counsel, I know there's an issue about whether Dr. Fielding either did or did not examine the bowel or run the bowel intraoperatively. But apart from that, leaving that issue apart, and whether that is something that is commonly done such that he can testify from custom and habit, taking that issue out, was there evidence by the defendant that there were no symptoms, or there was nothing in the record that would otherwise indicate that the Dr. Fielding should be suspicious for a perforation intraoperatively before she started exhibiting symptoms?
Okay, so to answer that question, our record opined that the running of the bowel would have been done regardless of symptoms, but Dr. Fielding doesn't.
So, all right, let me follow up that thread. So it's your claim that in an operation like this, that is customarily done?
Correct.
So if that's the case, isn't that inconsistent with your position that Dr. Fielding can't testify that he customarily runs the bowel?
Your Honor, did you say can or can't? I didn't hear what you said.
Well, isn't that inconsistent? You're saying in every case, it doesn't matter if the symptoms, he's got to run the bowel, right?
That's what our expert's saying, yes, Your Honor. And he can't prove.
And if that's true, though, then isn't your evidentiary point that he can't testify that he did it based on custom and practice? Isn't that not correct evidentiary-wise? Because if it's done in every case, then isn't it customary?
Well, it should be done in every case, Your Honor, but he can't prove through competent evidence that he actually did. And actually, the Rivera case out of the Court of Appeals gives stringent requirements of what an individual attempting to offer evidence has to prove. And those three requirements, Your Honor, and actually this court applied those requirements in the Gleason case, which I cited in my brief. The physician has to demonstrate a deliberate and repetitive practice that is invariably adhered to by a person in complete control of the circumstances. Dr. Fielding's, I want the court to note, Dr. Fielding's own expert testified that running the bowel is not necessarily the standard in every case. So there's a contradiction there. So that's a question of fact. Secondarily, the doctor attempting to offer the evidence.
But I'm talking about, but your position is that it doesn't matter that there were no symptoms. There was nothing to indicate intraoperatively that there was a perforation, that the bowel has to be run in every case.
Yes, that is my position. That is our expert's position, that it must be run. And it was incumbent to meet his burden. Dr. Fielding introduced competent evidence that he did so. He cannot do so because he cannot comport with the holding in Rivera. He cannot demonstrate a sufficient number of instances. I'd like to give the court an example. So if in my brief, I noted that when Dr. Fielding initially met with our client, he had told her, I may do this procedure laparoscopically. I may do this, I may convert it to an open. I don't know until I actually get in there. Now, It's important for the court to note that running the bowel in those two circumstances differs tremendously, because when you're running the bowel laparoscopically, you're running the bowel with laparoscopic instruments and you're visualizing the bowel. When you're running the bowel during an open procedure, you're actually touching, palpating.
Right, so I understand that. But you want to win this on an evidentiary point. You say he can't use custom and habit even though you say it's got to be done in every case.
It doesn't mean he does it in every case. He has to establish he does it in every case, Your Honor. And he can't do that because not only does he not demonstrate a sufficient number of instances, because he didn't testify as to how often in open procedures he did such, he also can't demonstrate that, yes, not only is it deliberate and repetitive, but I do the same thing every time. The circumstances are the same every time, because our client's unique medical presentation would demonstrate that it can't. Not everything is the same. Not every patient is the same. And in fact, the Court of Appeals in Rivera indicated that they're very hesitant in medical malpractice cases to admit custom and practice evidence because of that. So it's our position that they don't meet that Dr. Fielding never met his burden to prove that he ran the bowel. Therefore, they shouldn't have been entitled to summary judgment on that.
His expert doesn't say you have to run the bowel in every case.
You're correct, and that's a question of fact.
So they would have at least made their prima facie case.
But you know what the interesting fact, Your Honor, is? Dr. Fielding testified that he contradicts his expert. He says that the only way to determine whether or not there's intraoperative injury in 2009 is to run the bowel. So while their expert points to monitoring blood pressure and whatnot, Dr. Fielding said the only way to do it is to actually visualize it while you're running the bowel, and he can't prove he did that. So therefore, this issue needs to be hashed out at trial. There needs to be cross-examination, and a deposition is limited based in comparison to trial. We wouldn't be allowed to ask certain questions that we need to ask at trial, or Dr. Fielding's counsel to establish that this testimony is admissible. So I submit that based upon the record before this court, it's not admissible in support of summary judgment. His custom and practice, and any opinion born out of that testimony by their expert would likewise be speculative and thus inadmissible. But Your Honor,
I'm going to ask you you've run out of time, so I'm going to ask you to make your last point and finish up, please.
Sure. So even if the court finds they met their burden, there's still a question of fact because, again, Dr. Fielding admitted he perked the bowel. He admitted he did it on the 17th. And the record demonstrates he did it. So the question is, was it discoverable? Our expert says it was 0.5 centimeter hole. Their expert says no, because the hole may have been too small, and it may have, when the patient moved over the next 24 hours, it may have made the injury larger and more discoverable. So with that, Your Honor, I'm done.
Thank you. Mr. Zucker? Elliot Zucker?
You're muted.
Are you muted, sir?
Uh-oh. Ah,
Mr. Zucker?
he's probably screaming into the mic.
Yes. Well, all right. I just like the other case, I'm going to hold this. Mr. Scafidi, if you have your adversary's number, can you just text him on his cell phone and tell him we'll hold it till the end of the calendar so he can be heard?
I can send him an email. I don't have his. I don't know if he's at his office. So
that's the only way we have to notify him. Thank you.
Absolutely.
That would be fine.
Thank you.
Thank you. Okay, so we're going to call Drew versus Neal. Ms. Gustafsson?
Good afternoon, Your Honors. Hope you can hear me.
All right.
Ingrid Gustafsson appearing on behalf of the appellants. This court should reverse the Supreme Court's order granting the petition and reject the Supreme Court's novel interpretation of the disability retirement statutes at issue, which is advanced by neither party to this proceeding. The Supreme Court didn't disagree that there was credible evidence supporting the medical board's determination that at the time of retirement in 2010, the petitioner, Christopher Drew, was not disabled. Nonetheless, the court ordered the pension fund to award Drew accidental disability retirement because the medical board had found that he was disabled 7 years after his retirement. in 2017. And that interpretation should be rejected for a host of reasons. It's contrary to the most natural reading of this statute. It's contrary to common sense and to the statute's purposes. The purpose of disability retirement is to replace income when an individual is no longer able to carry out city service, not to provide additional income years after they have already retired. It's contrary to this court's case law in both Gulo and Bansley, and it's really contrary to the legislative scheme across the pension statutes. It's the default rule for all of the funds that you have to be disabled at the time of retirement in order to be entitled to disability retirement. And where the legislature has departed from that rule, it's only done so in very narrow circumstances, and it's been explicit. And it was not here. And the interpretation adopted by Supreme Court of this statute not only reads out in city service from the first sentence of the relevant statute, but it also would have substantial consequences for the fund, both administrative.
We can't hear you. Ms. Gustafson, we can't hear you. Can you try unmuting yourself?
My apologies, Your Honor. Can you hear me now?
Okay. Yes, we can.
Do you mind if I ask? Have I been muted for a while or only recently?
No. We caught it right at the beginning.
Okay. Thank you very much. And here in this case, the petitioner does not dispute that interpretation, that long-running interpretation and correct interpretation of the statute, but rather argues that there was no credible evidence that he was not disabled at the time of his retirement, which he appears to agree is the irrelevant time. However, when the board made its finding...
Counselor,
yes,
this is Judge Singh. I'm confused. Let's say that, I don't know, 20 years later, there's a finding of disability. So your client then can retroactively go back for make that application for accident disability?
Well, no, my position is the opposite, Your Honor, because I'm on the city side. My position would be that if you get a finding somehow by stringing along the process, which is what happened here, if you manage to get it years later, that doesn't entitle you.
Okay, so in 2010, what's the evidence in 2010 that there was no disability?
The medical board relied in large part on its own in-person examinations, which this court has held multiple times it's entitled to do, and not to accept the contrary opinions of the petitioner's doctors. Here in 2010, for example, the medical board determined that the range of motion in petitioner's shoulder, which had been the basis for the opinion that he was disabled from his doctor, was normal or close to normal, that the other tests it performs, manual muscle testing, sensory testing, was all normal. And his complaints, his subjective complaints at that time were limited to pain with overhead activities. Now, and it was based on its own in-person examination, which it's entitled to rely on, and that's the purpose of the medical board, to make its own independent investigation. It found that he was not incapacitated.
And I think part of that, the record indicates that part of the medical board's determination that filtered into or that supported that, or that they considered in terms of arriving at, is that after his 2006 incident, he was returned to full duty between 2006 to 2010. For 4 years, he was on full duty service. Correct?
That is also correct, Your Honor. And the medical board also reviewed in very careful detail, reviewed the reports that had been submitted by the petitioner, which did show degenerative changes, which is not uncommon in middle-aged individuals, but ultimately, based on the evidence that they had at the time, they determined there was no incapacitation. And if there was any question, they reviewed the application 3 more times in the next 2 years, and based on very similar evidence, found the petitioner was not incapacitated. The evidence that petitioner is relying on appeal and the condition that upon which he was ultimately found to be disabled, does not appear in the reports until years later, and is vastly different. Whereas in 2010,
you've run out of time, so I'm going to ask you to wrap up your argument.
Certainly, Your Honor, and I'd be happy to provide additional detail and rebuttal. But the diagnosis was different, the condition was different. It was not the same as in 2010, and so the medical board's determination that he was not disabled at that point was fully rational, and this court should reverse.
Thank you. Mr. Lukaszewski?
Yeah, Your Honor, just very quickly, and if the court, and I know you've read the papers, would just emphasize, though, before deciding the case in response to counsel's concluding point that the conditions were different when they found disability and when he retired. On pages 34 and 35 of my brief, and on pages 438 to 444 of the record, I think Your Honors will see that is absolutely not true. I don't understand how that can be argued. If you look at the MRIs, the EMGs, the fluoroscopic injections, when my client retired, he was not on full duty. The NYPD took him off full duty for shoulder issues, neck issues, and numbness in the upper right extremity.
Well, listen, I'm sorry to interrupt you, but the question isn't whether you put in evidence that, in fact, he was disabled on the operative date, but whether there was contrary evidence such that the medical board and the trustees were entitled to rely on it. You know, even if you had great evidence that in 2010, in the date of separation, that he was disabled, if there's evidence to some credible evidence to the contrary, doesn't that mean that we are bound to just uphold the determination of the trustees?
Your Honor, that's the language, that's the standard, but I would put to Your Honor, and if you'd give me 45 seconds on this point,
certainly
to take into account that the medical board exam is a closed door exam. Applicants are not allowed to videotape, audio tape, bring an attorney, bring a doctor, bring a union member, bring a wife, bring a priest, bring a rabbi. You find out the answer that the medical board is giving you on the day of, you do not get their written report for 10 to 15 weeks. That's the cause of the delays in these cases. Then you find out that the denial is based on an observational finding, that supposedly his arm was fine, supposedly he had full range of motion. This court does have the power to find that observational subjective finding completely contradictory to the objective diagnostic tests, to the MRIs.
Well,
that
where do you derive that from?
I thought
our case law was to the contrary, which is that the medical board is entitled to rely on its own observations. We say it over and over again.
Right, Your Honor, but if you read my papers, this court has found over and over again that the medical board, in reaching its conclusion, could not have accurately and fairly considered the evidence, could not have done an adequate physical exam. Every single one of petitioner's doctors, every single diagnostic test supports the fact that he did have a herniation in his neck, that it was pressing on the spinal column, that he did have a tear in his shoulder.
This is Judge Arm. I'm sorry to interrupt, but
No,
I understand what you're saying, right? But unless I'm mistaken, this record had six times that the medical board rejected his application for ADR, at least 6 times. And it was at the final time where they finally said, you know what? Okay, we'll give it to him.
Your Honor, but again, therein lies the problem. This is not permission to say the sky is red, to deny the evidence. I think the lower court was saying there should be almost a caveat to the prior findings that said, yes, I can't argue that the precedent is it has to be a disability at the time of retirement. But if a court can determine that the evidence isn't being fully and fairly considered, then that can't be the basis.
But that's asking us to that's like opening up a Pandora's box, because that means that then we would be, and that's as my colleague says, Justice Gish says, that would be running counter to the precedents, because that would mean that we would then have carte blanche to this. If we disagree with the medical board, for whatever reason, we're going to say we're going to overrule you. And in this case here, it's a little bit more difficult because it's just not one time that they rejected or they denied him the ADR. It's several times that they denied him the ADR.
Again, Your Honor,
that makes your case even harder, I think.
Your Honor, I agree. But if the court were to find, yes, absolutely, the evidence is so different on the first.
Let me tell you something. I ain't a doctor, much to my parents' chagrin.
No,
So you're going to ask me to look at medical records?
No, Your Honor, I'm not. I'm saying it is very simple to say that the conclusion of
there's
the.
no such thing as a simple appeal. Let me tell you that right now.
Again, Your Honor, if you just let me finish, please. I've tried to simplify it in the very few summary paragraphs that I've asked you to look at.
You did, and this has nothing to do with whether you did a good job or not. It has to really do with the fact of whether we should be making new findings of fact up here. Regarding his condition.
I would just ask, this is.
So I think we understand your argument. I'm going to ask you to finish up because you're out of time.
Okay, again, I would just ask that Your Honors, please, and it's not, I don't think, a medical determination. I think it's a factual determination that the exact complaints, the exact diagnoses, and the exact medical tests that they eventually say are disabling were present when they found him not to be disabled.
Well, are disabling in 2017. It's different. It degenerates.
But Your Honor, it's really not. If you look at the old tests that I've referenced in those two listings that I gave you, it's actually not. That's the head scratcher here. They're the same.
Okay.
Again, 34 to 35 in my brief, 438 to 444 in the record. Thank you. Thank you, Your Honor.
Thank you. Ms. Gustafson?
Yes, I'll be brief. I would agree that this court has repeatedly held that the medical board's own examination is credible evidence. I don't see what the basis here would be to reject, to say that its in-person examination was recorded inaccurately. I would like to make a few observations about pages 34 through 35 of the respondent's brief here. First, I would note that a lot of this information that is being relied on actually has to do with the petitioner's shoulder, which was not the basis that he was found to be disabled upon in 2017. It was his neck. So even if his shoulder condition is the same, the medical board didn't find it to be disabling at any time. And there is a vast difference between the condition of his cervical spine in 2010 and 2017. In 2010, actually, even looping up through 2011, what the evidence showed, there was a single disc bulge that was pressing on a nerve, but the cervical spine was normal. In 2017, he was diagnosed with cervical spine strain, herniated nucleus pulposus, so a condition of multiple herniations, most severe in two different places, which were impinging on the spinal cord. He had undergone additional treatments that weren't successful. And his subjective reports were also more serious, as were the board's examinations. As late as 2011, they found no restrictions in cervical range of motion, and they found they reached a different result in 2017. But that's not the relevant question under this statute. And if the court has no further questions, we will rest and ask for this court's reversal.
Okay. Thank you very much.
Thank you, Your Honors. Have a good day.
Counsel.
Thank you.
We're going to have a recall on People versus Perez. Ms. O'Shea?
No, not again.
Ms. O'Shea,
Oh,
you
no.
interrupted me. I said yes. What? All right. Let's try the other kind of technical glitch case here. Guido against Fielding.
Yes, can you hear me, Your Honor?
Yeah, I saw you came back in. All right, so we heard from your adversary. have an opportunity to respond, and then they'll be rebuttal.
Yes, and I apologize about the technical.
Justice,
Okay.
Justice
Um,
Swedish, I think Ms. O'Shea is in the lobby.
She's got to wait, right?
Okay.
Yeah. Yes,
Good
Stacy.
afternoon, Your Honors. Can you hear me now?
Oh, no.
No, you're going to have to wait.
Oh.
I can't, you're going to have to wait.
So the
Sorry.
same thing happened again when I unmuted
You know what? We'll deal with it. You'll have to wait. I will hear you, but I don't want to take up time with your technical problems. I have my own technical problems. Thank you. Okay. Mr. Zucker.
Yes, I am
Go
here.
ahead.
Okay, my expert did exactly what an expert was supposed to have done. They looked at the medical records, he pointed to the clinical signs and symptoms in the record, and based on that, he made a determination that either intraoperatively or in about the 24 hours or so postoperatively, there's no way to say that there's a discoverable perforation of the bowel. The plaintiff
Counsel, this is Judge Mendez. I have a question. Where does your expert get the following statement from? Dr. Fielding inspected and palpated the bowel and no injury was discovered. Additionally, no yellow bile was visualized. Where does he get that from?
Okay, I think there's sort of two things in there. The testimony about the inspection, Dr. Fielding testified over and over again that he did do an inspection on this case. Now, I know there's a
In
debate.
his testimony, Dr. Fielding said that? Or did he say,
No,
I would have, because he had no independent recollection?
Is that's his custom and practice. And I know this gets into the whole custom and practice argument and when that testimony is admissible and when it's not. My point is that even if we ignore this testimony, we presented a sufficient case that there was no signs and symptoms at that time, until about 24 hours or so after, that would have led anyone to believe that there was an intraoperative perforation.
Counselor, this is Judge Singh.
This,
Counselor, this is Judge Singh. My understanding of what the plaintiff is saying is that the bowel has to be run in every case, irrespective of whether there are signs of infection or not, because that's the standard of care. So how do you address, or how does your expert address that particular provision or that assertion?
well, my expert, there's, first of all, here there's a contradiction, okay? Because yes, my expert does say that an inspection of the bowel is not necessary in every single circumstances, and that when Dr. Fielding did it in this case, as was his custom and practice, he went beyond the call of duty, so to speak, given the signs and symptoms that were then present. Okay, and again, the signs and symptoms that were then present would not have led one to believe that there was any kind of bowel perforation. And he goes to the thing.
Why isn't that an issue of fact? Just a battle of the experts. One says you run the bowel in every open procedure like this, and one says no, you don't. Whether he did it or not, you know, is an evidentiary matter, you know, which I guess can be figured out at the trial court if he meets the Rivera standard or not.
I'm saying that there still must be more than this. Okay?
I know you're saying that, and I know your expert seems to say that, but did the plaintiff's expert raise an issue of fact by saying, no, the standard of care is that it needs to be run in every case, and we don't really have evidence here, or we at least have a question here about whether the bowel was run in this particular case?
I would say that this is a legal term in one of the cases, a feigned issue of fact. Okay?
Why?
Because the fact is that there is still no evidence that even if we accept arguendo for this particular case, that the bowel was not run, okay, there is still no evidence that running the bowel in this case at this time would have discovered anything. Okay, the plaintiff's expert very notably.
Well, why do you say that? But based on what? What's the basis for this argument that you're making?
Based on the clinical signs and symptoms with which my expert, our expert, referred. Okay, and these are signs and symptoms that the plaintiff's expert notably ignored. Okay,
Are
this
these,
is
are
not a
these
case where
signs
the
and
plaintiff's
symptoms,
expert said,
counsel, this is Judge Mendez. Are these signs and symptoms that can be seen immediately upon a perforation of a bowel?
right, this is what exactly what my expert talks about. He talks about the lack of yellow bile, the fact that there were no enteric contents. He talks about the stable vitals. And he says all of these things combined would lead one to think that there's no perforation. And these are things that continued into the postoperative period. And his review of the records includes the postoperative periods. And he talks about, again, the stable vitals, the spontaneous voiding, how the patient was febrile. All these things add up to a picture that our expert says that this is not a person who was experiencing a discoverable perforation at that time. And again, what I want to get to is that the plaintiff's expert doesn't disagree. The plaintiff's expert just ignores the record. Okay, the plaintiff's expert does not address all these signs.
Your
and symptoms.
adversary says that his expert says it doesn't matter if there were symptoms or not. In a procedure like this, you must run the bowel.
Well, look, I mean, the plaintiff's expert statements are so broad. The plaintiff's expert takes the position, apparently, as far as I can tell, that a bowel perforation is ipso facto discoverable in every kind of situation. Okay.
No, I don't think he's saying that. All he's saying is that you must run the bowel. That's the standard of care for this type of surgery, and maybe because this patient has gone through similar surgeries in the past, and that it should be run. Isn't that what the expert is saying? And your expert is saying the opposite. And should we be making that decision at this level, or is that an issue of fact then? As was said earlier, a battle of the experts.
Okay, he's not really saying the opposite because, again, the testimony is that, again, this goes back to the custom and practice argument, but the testimony is from Dr. Fielding that he would have done that. And
Counsel, this is Judge Jordan. I'm sorry to interrupt, but it sounds like you're saying that there was no basis based on the medical record during the operation. There was no medical basis for him to run the bowel because all the signs were there to indicate everything was copacetic, everything was good, right? That's basically what your expert's saying, correct? Is saying in the affirmation, correct? So that could it be argued then that it should be a trier of fact to determine whether or not running the bowel will be sort of like the last step to do to actually confirm everything that's happening? In other words, the two are not separated, the two sort of go in tandem. Because if you've got, I mean, it could be a situation where you've got the great vital signs, everything is running perfectly, but there could be something if you did the run, you would find that the vitals didn't pick up. I mean, couldn't that be an argument? I mean, couldn't that be a factual issue that could happen? I mean, we're dealing with medical. I mean, we're dealing with failure to diagnose, I think.
Yes, we are. I mean, that's the issue that this particular part of the motion decided.
Yeah. I mean, did you follow what I was saying?
I did, but I still think the point is that even from a purely causational standpoint, okay, the plaintiff has to be able to point to something in the record that says that if this had been done, okay, it would have led to something, okay?
Yeah, that's true, but I don't think that was the basis of your summary judgment motion. Your summary judgment motion was that the standard of care was met.
No, my standard, I think that's with due respect to
I agree. There's this causation issue that is pretty difficult always in failure to diagnose cases. Always.
I agree. It is a difficult issue, Your Honor, but the fact is,
I think you've exceeded your time. I'm going to let you finish up, and then we're going to hear from your adversary.
Okay, I still think for an opposing expert affidavit to be sufficient, they have to be able to point to clinical things in the record itself that point to the idea that having done this, it would have yielded a different result. The plaintiff's expert can't do that here, and instead bases their reason purely on hindsight. Thank you.
Thank you. Mr. Scafidi?
Thank you, Your Honor. I'll be brief. We can't ignore the testimony in this matter. Dr. Fielding can't prove he ran the bowel, so therefore he can't prove what he saw or what he didn't see intraoperatively. There's no mention in the operative report that he ran the bowel, and he has no recollection of the surgery itself. Therefore, the burden Did you want to say
All right,
something?
counsel. Yeah, counsel. This is Judge Drawing. I mean, he's relying on the fact that the vitals, everything on the surface looked perfect. I mean, looks like everything was good to go. And I'm hearing from you and from your expert that if he had run the bowel, that would have been the sort of like the capping on, like, okay, now you've done everything that you should have done, and that's the end of it. And then and had he done that and there was a perforation, you wouldn't have a failure to diagnose because he did everything he was supposed to do.
Your Honor, we know for a fact that he injured the bowel on August 17th.
I understand that. I'm just saying that, but that's the argument that you're raising about how there's a factual issue here.
Yes, and the record indicates a 0.5 centimeter hole in the small intestine. There's a question. Let's say, I disagree that they met their burden to even get here, but there's a question of fact as to whether or not running the bowel would have yielded discovery of that. And there's no opinion from Dr. Fielding's expert that the bile would have been immediate. As what I mean by that is intraoperatively versus postoperatively.
Right. What I'm suggesting is, had he run it and it came up negative, there was nothing there, then even later on post-op, that there was some sort of preparation, you would have a harder argument saying there was a failure to diagnose.
If there was competent evidence in the record that he did so and that it was not discoverable, yes.
You would have a harder argument. Okay.
But that doesn't present here.
Yeah, I understand. I'm just, okay, got it.
Counselor, this is Judge Singh. I just have one question of you. Your argument to us is your expert specifically states that running the bowel in every case is the standard of care, correct?
Correct.
Does he specifically say that? What does he specifically say with respect to the standard of care?
So he says that under the circumstances of this case, the previous bowel surgeries, the risk of adhesions, the standard of care is to run the bowel in this circumstance, regardless of whether or not he suspected or he saw or there was any indication, like their expert says, that there was.
Well, that's something a little different. That's not in every case. That's in her particular case. She should have run the bell.
He specifically states here, Your Honor. I'd have to pull and look to see.
Yeah, I'm gonna relook at it myself to see exactly what your expert says.
I'm sorry. I didn't mean to cut you off. I know for a fact he states that in this case specifically, the standard of care.
That is actually how I understood his affidavit to begin with. I was a little surprised when you argued here that he said that you have to run it in every case. You know, therein lies some of the problem here. Okay. I think we understand your arguments. Anything further, colleagues?
Yeah.
Questions?
Either way, he can't. Oh, I'm sorry. I apologize.
Yeah. Okay.
Thank you, Your Honor.
All right. Thank you both. I appreciate your patience and waiting. Thank you. All right. People versus Perez. Okay. Ms. O'Shea, you're up.
May it please the court, my name is Sheila O'Shea and I represent the respondent on this appeal. The issue here, as I agree with my adversary, is whether the defendant was afforded an opportunity to withdraw his plea. That's certainly the law under Selikoff. However, the law does not require that the resentencing judge affirmatively inform a defendant that he's entitled to withdraw his plea before the imposition of post-release supervision. Even Franklin doesn't say that. However, even if such a duty arose under certain circumstances, I submit that those circumstances were not present in this case, given the record before the court. At the resentencing, the judge expressly asked the defense counsel, how he wanted to proceed, whether he wanted to file papers on defendant's behalf, whether there's something he wanted to discuss with the district attorney's office. Defense counsel said he'd spoken to defendant about the issue. He was not in a position to file papers at the time, and that defendant was prepared to accept the amended sentence. He also said he'd explained to the defendant that he should have been sentenced to 5 years of post-release supervision. So I think it's fair. The plain inference, I think, from this record is that the defendant consented to the imposition of post-release supervision. Also, I think a fair inference from the record is it was a rational decision on the defendant's part not to attempt to withdraw his plea. He knew that if he refrained from undoing his negotiated sentence, he would be eligible for conditional release within several weeks. However, if the defendant successfully moved to withdraw his plea, he would have faced a trial on the B felony count, first degree robbery, and would have been exposed to an additional 16 and a half years in prison. So it's certainly good reason for him not to wish to upset the boat, as it were. So I think the plain inference from the record is that the defendant made a conscious decision not to withdraw his plea, and his decision to do so was voluntary and intelligent. And I don't think Franklin dictates a different result. Not only is Franklin distinguishable on the facts, but I think Franklin does not propose the standard that my adversary advocates that it does.
But he was relying in his main argument on Padillo. Does that command a different result?
You know, I was, as my adversary was speaking, I was looking through the reply brief, and honestly, I couldn't find it, so I apologize. I haven't looked at the case, so I am afraid I can't answer your question.
Thank you. All right, anything further?
Not for me.
All right, Mr. Weiner, you have rebuttal.
Thank you, Your Honor. Franklin absolutely does dictate a different result. This was the precise argument that the prosecution raised in Franklin, that the court had no affirmative duty to offer plea withdrawal, that the onus was on the defendant. This is almost word for word what the prosecution said in Franklin, and the Third Department rejected those arguments. The Third Department didn't ask, would this defendant have actually withdrawn his plea? The Third Department didn't ask, did counsel think it was a good idea? Did we think it was a good idea? It didn't ask any of those questions. What it said is, no, the defendant had to be given an opportunity to withdraw his plea. And in order to give him that opportunity, a general opportunity to object wasn't enough. And I think that's so crucial to this whole case. It was Mr. Perez's decision whether or not he wanted plea withdrawal. Whether this court thinks it would have been rational, whether his attorney would have thought it would have been rational is really not relevant. And neither he nor his attorney has ever asked, do you want to withdraw your plea? He's never asked that question. He never says, yes, I want my plea back. He doesn't. And what counsel is saying, I urge the court to look at these minutes. What counsel is saying is, there's no legal basis for us to challenge the imposition of PRS. That was true. There was no legal basis for them to challenge the imposition of PRS. It was required, but Mr. Perez had to be given an opportunity to withdraw his plea before that sentence was imposed, and he was never given that opportunity. And for those reasons, we would respectfully request that this court vacate Mr. Perez's sentence and remit for resentencing. Thank you, Your Honors.
All right, thank you. Thank you both. Thank you for your patience in waiting. And the appellate division is now closed.